This is Chevalier-Firescu.
Yes, Mr. Gupta.
Thank you. My lords, my ladies, I appear on behalf of the appellant, HSBC Bank plc, the respondent before the tribunal, together with my learned junior Zafar Ansari, my learned friends Oliver Siegel KC and Elaine Banton appear for Ms. Chevalier-Firescu, the claimant before the tribunal. I'll refer to the parties as the claimant in the bank or HSBC. My lord, my ladies, the structure which I propose to adopt is in three parts. First, briefly, the scope of the appeal before the court. Second, our submissions on ground 1, the race discrimination claim. And third, our submissions on grounds 2, 3 and 5 in respect to the just and equitable extension of time.
Yes, thank you.
Part 1, the limited scope of the appeal. As the court will have seen from the papers, this is an appeal from the judgment of the EAT, Her Honour Judge Tucker, allowing the claimant's appeal against the judgment of the Employment Tribunal, Employment Judge Berger. May I invite the court to turn up the ET judgment at this stage, please? It is in the call bundle at page 137. Your Lordship and Ladyships will have seen this and will have read this, but just to put this appeal in context, if the court could please just read paragraph 1
Of the judge, of the judgment,
of
formally,
the judgment,
rather than the reasons,
indeed,
yes.
the judgment, not the reasons, the judgment.
Yep.
The tribunal judge decided that between May to July 2018, when the claimant was not appointed to the GCB Global Career Band 3 vacancy at the respondent, the claim had been presented out of time.
Yep.
There is no extant appeal against that part of the judgment. Paragraph 2, the first sentence, the decision by the employment judge that the specific role was not part of a continuing act of alleged continued recruitment arrangements and non-appointment of the claimant. Again, there is no extant appeal in relation to that part of the judgment. Still in paragraph 2, it is not just and equitable to extend time. The tribunal does not have jurisdiction to consider this claim, i.e. the non-appointment of the role, pursuant to section 123 of the Equality Act. Of course, there is an issue before this court in relation to that decision. That was the claimant's ground 2 before the EAT and is our grounds 2, 3 and 5 before this court. And it relates to the claimant's claims of victimisation and sex discrimination up to that period, mid-July 2018. Then in paragraph 3 of the judgment, through to paragraph 5, which I invite you to read, these concern the determination of the other issue that was before the tribunal, which is the section 39 issue. May I just invite you to remind yourselves.
Why are you asking us to read those, given that they're not an issue? Oh, I see, sorry.
Because of the periods and to set the context in relation to the
Right,
the way in
no,
which
no
the claimant
reason.
puts her case.
I'm so sorry to interrupt at this very early stage. Just going back to paragraph 3, if one reads the particulars of the claimant's first claim, as I understand it, one of the points she was making is that things that happened between those dates were acts, some of them were acts of victimisation. I misunderstood that.
That is right, my lady. The claimant put her claim very broadly in terms of the period of complaints, and she did claim of discrimination and victimisation particularly victimisation, and we say sex discrimination
Mm.
on an ongoing and continuing basis, including in a second claim. And we say, as you'll have seen from the papers, that in respect of race discrimination, there was a discrete claim related only to an event on the 29th of September 2020. So that is why I'm inviting the court to read these paragraphs to set those points in issue at this stage. So,
Okay.
Milady, I think to answer your question, in respect of paragraphs 3 to 5,
Yeah.
there were two preliminary issues before the Employment Tribunal. One was time limits, and two was Section 39 in respect of the later allegations, if I can put it that way. The first two paragraphs of the judgment deal with the time point, and the later paragraphs, paragraphs 3 to 5 of this judgment, deal with the Section 39 point. And the judge found both issues, the time point and the Section 39 point, against the claimant. And so he then concluded, in respect of, at paragraph 6, all of the claimant's claims are therefore dismissed.
I suppose I haven't really asked a very clear question. The point I was really trying to get at was that I'm not sure that when one reads the particulars of the claimant's first claim, she was claiming that all the things that happened from 2018 onwards were arrangements for offering employment. What part of the claims, at any rate, seems to have been the things that happened later were further acts, were acts of victimisation.
Yes, and Milady...
And that the victimisation was a continuing act, which started with stopping her recruitment in 2018, and then it just carried on with other examples that she gives in her particulars.
Milady, that's right. She claimed they were victimisation, acts of victim. There were
Be
acts of
accurate.
victimisation.
Sorry, just so they were detriments.
Yes.
Sorry, I know I'm being pompous, but I want to use the language of the legislation. Is that right?
Yes, that's
She may not have used it, but that's what she meant.
That is right.
Yeah.
But Milady, in order for the tribunal to have jurisdiction to determine those complaints, the claimant had to bring herself within the provisions of the Equality Act and bring herself within the provisions of Section 39. She needed to show and establish that she was a job applicant for the shorthand at the time.
I followed that, and the employment judge accepted that she was in relation to the period of the Joneses, and I forget when,
July 2018.
2018.
July 2018.
Right, but what she seems to have been saying was that not offering me the employment then, and various things that happened later, were acts of victimisation, and they were continuing acts, and I just don't see that being grappled with in these paragraphs of the judgment.
Well,
At the end of the stick.
Milady, no, you don't. If we look back again at paragraph 2, the judge there decides, this is a summary, the specific role was not part of a continuing act of alleged continued recruitment arrangements and non-appointment of the claimant.
No, I've read that.
Because what the claimant said is, paraphrasing, everything that happened thereafter was all about victimisation in the context of being offered a role and not being given a role. And so in that context, she was on an ongoing basis saying all these lunches and coffees and meetings were all in respect of recruitment, and therefore were all arrangements within Section 39. And the judge did grapple with that, and I'll come to the reasons in respect to that. He did grapple with it, and he found no. But in any event, Milady, that issue, whether or not there was a continuing act, is not before this court.
Okay, well, let's park that for the moment. We may have to come back to it if we're still unclear later on.
Yes, of course. So we were looking at paragraphs 3 to 5 of the judgment, and it's helpful just in terms of the dates that are referred to. So paragraph 3, the claimant's claims in respect to the alleged actions, events, comments, discussions, lunches, meetings, texts, emails and correspondence with or by specified employees of the respondent between February 2019 to March 2021 were not arrangements for deciding who to offer employment and were not refusals to offer employment to the claimant. And then specifically for the purposes of section 39, in respect to the claimant's allegations between February 2019 and March 2021, there was no authorised employment or opportunity. There was no authorised employment or opportunity to offer.
Is that just an amplification of 3? I don't quite understand
Yes.
what the difference is.
Yes.
I mean, this is not a very well structured judgment, or indeed possibly the reasons
My
either.
Lord,
but
I
I
don't
mean,
accept that, but it could have been better. It could have been phrased.
you normally just say in the judgment what or effectively this ought to look like the order, and
My
this
Lord,
is a
yes.
bit wordy and has more in it than is necessary. Which
we say is helpful. In this
Sorry?
context. Which we say is helpful in this context. But my Lord, yes, in respect of 3, that itself is the section 39 conclusion, but the judge there is referring at paragraph 4 to the relevant statutory provision, which we say is helpful and provides context.
well, it'd be all right. Okay.
And then
but
5.
section 3 already refers to the relevant, because the language of were not arrangements or were not refusals.
My Lord, yes.
Yeah.
My Lord, yes.
Okay.
But 3, 4 and 5 concern the determination of the section 39 equality issue. During that period, the claimant was not within the scope of section 39, and there is no issue before this court as to the correctness of that section 39 issue. And then at paragraph 6, all of the claimant's claims were dismissed. And before the employment judge, there were 2 claims, 2 employment tribunal forms. And so that's comprised at that stage both the first claim, which had been submitted to the tribunal on the 1st of November 2020, and the second claim, and the claimant, as the court knows, successfully appealed in respect of the strikeout of the second claim. But this court is not concerned with the second claim.
No, and just purely from my own understanding of the situation we're in, I appreciate it doesn't affect any of the issues before us. Won't the findings made about being an applicant for employment, which cover all or most of the period covered by the second claim, even though for procedural reasons the EAT held it was wrong to strike it out, inevitably apply to the second claim as well?
My Lord, yes.
Yeah.
I mean, that was indeed our position,
Yes, I see.
which found favour with Employment Judge Berger, but there was the procedural wrinkle identified by the EAT judge, and
Yes.
we weren't granted permission in
Yes,
respect of that.
very well.
And so the conclusion reached by the Employment Tribunal judge was to strike out, for the purposes of this appeal, the claimant's race discrimination claim.
Sorry, just say it again. I was
For
just
the purposes of this appeal,
yeah.
the decisions made by the Employment Tribunal judge were to strike out the claimant's race discrimination claim.
What, because of the failure to extend jurisdiction?
No, we say no.
Okay,
We
well,
say
just
because I'm coming to it, but because it wasn't within the scope of section 39. In a nutshell, our
yes,
position
I see. Yeah, I see.
is that the claimant's race discrimination claim was limited to
Yeah.
alleged remarks on the 29th of September 2020. The claim had been submitted on the 1st of November 2020. There was no issue in
There's
respect
no
of
time
time.
issue. No, if
If wasn't- My lord, yes. If I'm right about that, if she was within the section 39 jurisdiction of the tribunal, then there was no time point.
Yeah.
And then the second decision for the purposes of this court is that the tribunal declined to exercise its just and equitable discretion to extend time in respect of the claimant's victimisation and sex discrimination claims, which related to the period up to July 2018, when she had been found to be a job applicant within the scope of Section 39. That wasn't an issue.
Can I just ask a question about
Yes,
the
of
race
course.
claim, please? Again, I've read the claimant's particulars of, this is just a question. Is one potential interpretation of those the conversation about the Lebanese managers casts a retrospective light on what has happened in 2018?
That is what the claimant now seeks to argue before this court. It was not the way in which the claimant's claim was pleaded, and if anything is taken from that pleading, it might be said to be future looking rather than looking backwards. We say that the remarks in respect to the Lebanese connection were themselves relied on by the claimant as her only claim of race discrimination, limited specifically to that date. And of course, the avoidance of any doubt, we don't accept there was discrimination, but
That's a different
none
that is a
of the
different issue.
substantive claims, of course, were determined. That was the whole point.
Yeah. So
So do you rely on any passage in the particular claim which shows that that is the way that she was pleading her case?
Yes, I do.
Right.
And I'll take
yeah, you'll be coming to that
to
later.
it very, very shortly.
Thank
I
No, don't,
Don't do
it's
that.
helpful to us all just to get
absolutely.
our heads clear on one or two points like this, but not at the risk of you being taken out of your course. So
Thank you, my Lord.
Yeah.
And we say, in respect of those two decisions made by the Employment Tribunal judge that I've just outlined, that the Employment Tribunal judge was entitled to reach those decisions on the material before him, and that the EAT wrongly allowed the claimant's appeal against those orders. We submit first that the EAT judge fundamentally misunderstood the limited ambit of the claimant's race discrimination claim and ought not to have allowed the appeal against its strikeout. That's our ground one.
this is just trailing, is it? I'm not going to write all this down because you're not making all these submissions.
No, this
Right.
is just what are the issues. This is my part one.
Yes,
I'm
okay.
about to come to,
Okay, yeah.
and then the second, our second submission is that the EAT impermissibly interfered in the tribunal's exercise of his discretion not to extend time on a just and equitable basis in respect of the claimant's victimisation and sex discrimination claims, and that's grounds 2, 3 and 5.
Yep.
And so now I come to part 2 of our submissions, which is ground 1 of our notice of appeal, and that concerns the claimant's race discrimination claim.
Yeah.
And as the court will have seen, we submit that the EAT judgment is perverse and or errs in law, and that it is obviously wrong, proceeding on a fundamental misunderstanding of the race discrimination claim. For the court's reference, we deal with this in our skeleton argument, which is in the core bundle at page 16, and we make the following 6 points in relation to this ground.
So are you, I mean, I don't mind this at all, are you basically simply rehearsing what's in your skeleton, relevant to whether I take a note or not?
My
Or
Lord,
not? You're packaging it slightly differently.
My Lord, and developing it.
Yes, I
we
see.
haven't
Okay.
set
No,
out-
that's fine. But
We
where?
haven't set out these 6 points quite like this, but I can give you the cross references to the skeleton as I go through the points.
Well, that would be helpful, I suppose. Yes, but what was the passage you referred to just now altogether?
Well, I haven't come to it yet.
Oh, I see. Okay.
But,
No, off you
but
go.
in terms
off you
of,
go.
my lord, in terms of the 6 points, point 1, the race discrimination claim was limited to a single alleged remark made on the 29th of September 2020. That's our skeleton argument, paragraph 24. Point 2,
So, you must think I'm obsessed by how I take my notes. Again, are you just trailing these points, or are you actually?
my lord, at this stage, I'm identifying the 6 points so you have them, and then I will
Then you'll come
remind
back.
and
Okay.
report where I
Okay.
am in
Yeah,
respect to the
that's
6
fine.
points.
So limited to a single alleged remark.
On the 29th of September 2020.
Yeah. And you were giving us a skeleton cross-reference.
Paragraph 24.
Thank you.
Point 2, the employment judge was right to approach the strikeout application on the basis of the claimant's pleaded case as reflected in her draft of the list of issues. Third, the judge correctly identified the basis of the claimant's race discrimination claim at paragraph 73 of his reasons. And for the court's note, that's a core bundle, page 148, and we'll come to it. 4, there was no issue in respect of time limits regarding this claim alleged remark. Our skeleton, paragraph 23. Point 5, the tribunal judge struck the claim out because it related to the period after mid-July 2018, when he found as a fact that the claimant was not a job applicant within the meaning of section 39. Our skeleton argument, paragraphs 23 and 25. And 6, the EAT judge misunderstood the position in respect to the race discrimination claim and wrongly allowed an appeal against its strikeout. My lord, my ladies, turning then to my submissions on the first point, the pleaded race discrimination claim was limited to a single alleged remark made on the 29th of September 2020. My lady, Lady Justice Laing has asked me about the pleaded case. It is, of course, in the supplemental bundle and starts at page 1. And the paragraph that we rely on as setting out the claimant's case in respect of this claim is at page 12 of the supplemental bundle, page 13 of the supplemental bundle at paragraph 82, the top of page 13. And I'll take you to 81 and 83 to provide context, but for now, if we look at paragraph 82 in isolation,
Yes.
so I can see the court has read that, and just to set context around that paragraph, paragraph 81, on the 29th of September 2020, the claimant had a face-to-face meeting with Eric Dutoit, the relevant hiring manager at HSBC. Mr. Dutoit confirmed that the reason that the claimant was not hired so far was the feedback received from the claimant's old boss at Barclays. Mr. Dutoit confirmed that he'd received comments from the first respondent. And then paragraph 82, and crucially, additionally, when speaking about the realistic possibility of the claimant and Mr. Dutoit working together in the future, note, not looking back but looking forward to answer Lady Justice Laing's question, Mr. Dutoit was worried that the equity derivatives team at HSBC included a number of senior people from a Lebanese background, which remain in direct and easy contact with Makram Fares, the claimant's old boss, also of Lebanese origin, and this situation would make it more difficult to hire the claimant in the future. And then paragraph 83, during the meeting on the 29th of September, Mr. Dutoit further confirmed that the bad feedback received about the claimant had emanated from one person at Barclays. So we say the claimant's case, as pleaded in respect of race discrimination, was limited to those specific remarks that she relies on as having been made, which are identified there.
And just so I can understand this, it's not, I think it's pretty clear, I suppose we don't know, clearly, as we've all been told, the claimant's intelligent and has a good deal of experience,
Indeed.
but he's not a lawyer, and this doesn't look as though it is written by a lawyer.
Well,
we don't know.
my lord, we'll dig out the reference that when the claimant has said, I'll be corrected from behind me if I'm wrong, the claimant has said that although she drafted this herself, she did have some assistance, I believe, from a direct access
No,
barrister.
I wasn't really, I was just
well,
hang on one second. It was really just preliminary to saying that this doesn't neatly analyse what the acts complained of are. This is a sort of narrative, and you have to pick out the acts complained of. Is that a fair?
my lord, but the claimant then went on to prepare.
Well, I know.
List of issues,
I was
but-
about to say the list of issues perhaps does that job, though. But I'm just being laborious. I'm sorry.
No, not at all, my lord.
So this is, you can't. You have, if it is an act complained of, what is the detriment?
Well, my lord, the claimant, we say, explains in the list of issues, her version of the list of issues attached to the tribunal's judgment, that she found these remarks made by Mr. Dutoit offensive.
Yes, I see. So the detriment is the upset that they cause.
My lord, precisely that. And that's precisely what she relies on.
Hang on one second.
Can I just take you back, if you finish answering my lord's point, to some earlier paragraphs in the
Yes, of course, my lady.
So paragraph 7 is headed discrimination, and there's a general allegation that the respondents have subjected the claimant to sex discrimination, victimisation and race discrimination in the recruitment process and by failing to offer her employment.
My lady, yes.
Right, now if you go on,
Yes.
So sorry, I was just making a note. Where was my lady asking you
I'm
about?
so sorry, paragraph 7 of the particular claim.
Yeah.
SB2. She then talks about, in addition, paragraph 9, in addition to unlawful acts of discrimination, sponsors have used concealment tactics to mislead the claimant about the nature and intention of the events, demonstrating they were aware they were discriminating. 10, concealment, so on and so forth. Concealment of discrimination acts affected the claimant's future career. She was not aware of their extent and represented victimisation act itself. And then in paragraph 11, Second respondent has created an environment where sex, race discrimination, victimisation practice, blah, blah, blah. Manager is afraid even to hire the best candidate for second respondent. She's complained about being discriminated in the past, and even more so where she complained against a Lebanese origin manager. So I'm just wondering whether one possible construction to be put on paragraph 11 is that she's relying on the much later conversation as evidence of what was going on at the time she did get the job in 2018.
My lady, certainly that's how the claimant wishes to put it now.
Right.
But we say that that's not a fair reading of the paragraphs. And in respect of what is said there, in effect, that is a complaint of victimisation. So if one looks at that second sentence, where managers are afraid to hire if she has complained about being discriminated in the past, and even more so where she complained about a Lebanese origin manager. That is a description, we say, of her victimisation claim. And the reference to the manager against whom she'd complained being of Lebanese origin is neither here nor there. She is the one describing him that way. She is saying, he's the one I complained of, he is Lebanese. It's not relevant.
Well, the whole thing, it is a great pity. I shouldn't say this in employment. It's a great pity this isn't pleaded by a lawyer, but she must have had something in mind in referring to the fact that he was of Lebanese origin.
Well,
it's hard. It's hard to see how, I suppose, how it's a race discrimination claim.
my lord, quite. The claimant does refer to him as of Lebanese origin, and my learned friend's skeleton refers to an individual as presumed to be Lebanese. Those presumptions or descriptions don't amount to an allegation of race discrimination against the bank.
Well, so it looks as though, again, I may be misreading this document. Reference in paragraph 11, it's a slightly elusive reference, is a reference to what's described in paragraph 82, which you say was understood to be a claim of race discrimination.
Well,
But whether or not it's a good claim is another issue. But so really, I suppose I'm asking you: are the paragraph 11 linked to paragraph 82?
my lady, our submission is not.
Right.
This claim was pleaded by an individual, but with some legal assistance, as she herself said, and the reference for that is paragraph 174 of her witness statement.
Well, it doesn't really matter, does it? I mean, thank you. I'm glad to have that. But
Page 186 of the supplemental bundle.
I know I raised it, but it's it was only preliminary to just trying to read the document slightly differently if it's professionally pleaded than if it's pleaded by a layperson.
But my lord, in this case, the claimant says in the paragraph I've just referred to that she had legal advice from a direct access barrister, and your lordship, your ladyships will have seen lots of particulars of claim, and this doesn't look as if it had been prepared only
I
by
take
a
your
litigant
point.
in person.
I take your point.
On the
Perhaps,
contrary.
I'm sure we don't know the name of the direct access barrister, but if it was done by if it was totally done by the direct access barrister, well, one hoped it would have been more focused.
His or her name would have been at the foot of the pleading.
No, I hesitate to interrupt, but my learned friends referred you quite properly to supplementary bundle page 186,
Yes.
174, 175.
Yeah.
My learned friend, all those behind her, put an interpretation on those paragraphs that is not one I would
Well, I
suggest
know,
is
but
natural.
she's
but-
making her submissions at the
No,
moment.
I'm just saying, but on instructions, if it helps, I can confirm what is said in paragraph 175, which is that she did draft this herself.
Thank you. Anyway, look, I wonder what
Well,
the lady's put to you the interrelationship between paragraph 11 and paragraph 82. We may have to come back and hear more submissions about it later, but clearly you are saying that any uncertainties are resolved when one looks at the list of issues. So I think the sooner we get to that, the better. Is that where you're going next?
my lord, yes, but if we look back at paragraph 82,
Yes.
that paragraph makes very clear, we say, that it's about remarks about working together in the future. So it was forward-looking, not
I've
backward.
got that point. I've
So
underlined
when
it
one
as well.
looks at paragraph 11 in that context, paragraph 82 is the only, we say, claim in respect of race discrimination.
And again, I have to raise lots of questions that probably
Not sure.
aren't fundamental. They just help me get the flavour of it. Why would it be, if, yes, I see.
Was my
It doesn't
lord
seem
going
to me clear that to be told that you may be victimised because by Lebanese in firm A, because you complained about a Lebanese manager in firm B, I can see that's upsetting, but it's upsetting because it's victimisation. Why is it a claim of race discrimination? She's not, it's not been suggested that she is, I don't know what her nationality is, it probably appears somewhere, but some nationality against which Lebanese people might be thought to have a prejudice.
My lord, I'm glad you asked that question. Why is it race? I also say it's really a victimisation claim, not a race discrimination claim, but the claimant puts it as a race discrimination
It's
claim.
not an issue we're entitled to answer, I think, on the issues in this appeal.
No, but it's a very fair question. It is a struggle to understand how the alleged remarks amount to a claim of race discrimination, but for
Well, there we
present
are.
purposes, we
There we
proceed
are.
on the basis that it's
I don't want to start another hair running, but one does need to get some sort of background feel for it before focusing on the real issues. Yeah.
My lord, thank you. And we say, this is still my point one,
Yeah.
that we'll now look at the list of issues.
Yes.
That was attached as Schedule A to the tribunal judgment. It appears in the core bundle at page 158. So it starts at 158. For the court's note, you'll have seen that this is referred to by the judge at paragraph 5, where he says it's necessary to identify the relevant claims and issues. In the absence of confirmed agreement, I used the claimant's second draft, dated the 4th of June 2021, which is set out at Schedule A, and that's what we're now looking at. So this is the claimant's draft of the list of issues that was before him.
And you were there. Was it agreed for the purpose of the hearing, without prejudice to it not being an agreed list of issues, that would be a working tool, or is it something he just did subsequently in writing his judgment? I say you were there. I appreciate it was a long time ago.
My lord, I was there, and it was a long time ago. I've tried to remind myself of what precisely happened then. My lord, you'll recall that there were 2 dates of calling
Yes,
the hearing.
one where she was represented, one where she wasn't.
Yes, and I'll be corrected if I'm wrong, but it looks as though we didn't agree the list of issues.
No.
The judge did have some discussion with the claimant about the list of issues, but on the 2nd day of the hearing in September. But I can't say that there was specific discussion about the specific issue that I'm going to take your lord and ladyship's to. So there was some discussion about the document. It may be that in the intervening period between day 1 and day 2 of the PH, the judge had been focusing on that document, for example.
Okay, thank you.
So the list of issues is at page 158.
Yeah.
And just briefly now, before we look at the claim in respect of race discrimination, to show you the structure of this list. Section A, time points are identified. Then at the bottom of the first page, victimisation, issue 2. And then at the top of page 23, internal numbering CB 159. The claimant identifies at paragraph 2.1 the protected acts she relies on in respect of her victimisation claim. At 2.2, she deals with knowledge. And then at 2.3, she sets out the following alleged detriments that she relies on in respect to victimisation. And those are set out from 2.3.1 onwards. So alleged victimisation starting from 2.3.1 under the heading by preventing the claimant as a job applicant, the best candidate from obtaining a job, onwards, through page 24, through page 25, and just we'll touch on the issue at 2.3.26, which is of the 29th of September 2020. But that's there as a claim of victimisation detriment. We can come back to that. But it's along the lines that my Lord Justice Underhill put, which is the way in which paragraph 82 is framed seems to be more akin to victimisation. I hope that's a fair
The
summary.
cross-references to paragraphs 81 to 83.
Yes.
But it appears from this, this rather concerns the impression I got from this particular claim, that the claimant was saying, I was subjected to a series of detriments throughout the period.
Yes.
And they all were part of this victimisation.
Milady, yes, she does indeed say that, and that's why the tribunal judge had to grapple with the section 39 point and the continuing act point. So that's 2.3.26, victimisation claim in respect of that conversation, the alleged conversation on that date. And then if we go forward,
I'm so sorry to interrupt
Not
again.
at all.
Did the claimant have to show, in relation to the detriments on which she relied in supporting her victimisation claim, that she was within section 39 throughout the relevant period?
well, Milady, if I can take that question in 2 parts. If your question is, did she need to show it for every single claim through the period to be within section 39? Not necessarily. The continuing, in order to succeed on any single one of them. So she could have, if she was within section 39, for any allegation, for example, in 2019 or 2020, if she was within the scope of section 39, that could be the case for one particular alleged detriment. But of course, there was also the time point. So she, in order post July 2018 to find jurisdiction for the tribunal to determine the claim, it had to be first A, within section 39, and B, within time. In the just negligible to extend time. But for our purposes, we're not, Milady, concerned with that, because the tribunal judge found that section 39 did not apply. Well, she wasn't within the scope of section 39 in respect of anything after mid.
But is that an answer to the victimisation claim? That's what I was trying to get at by my rather real phrase.
We haven't, curious enough, we haven't been given the Act.
I was just looking for it myself.
We all think we know it, possibly some of us more than others. But isn't this the position? In order to bring a claim under section 39, you have, well, the first thing is, does section 39 cover victimisation?
Yes.
I'm not messaging, I'm looking up section 39.
And section 39 is set out in the tribunal's judgment
Let's have a look.
at page 148 of the core bundle. And to answer your question,
Yeah, it's section 39(3) is
Yes,
employee must not victimise.
Yes.
What audit?
so it's at the top of page 149. So 39(1),
Yes, I
employer
see.
A must not discriminate, and subsection 3 must not victimise.
So if you cease,
She was never an employee, my lord.
no, I understand that. If you cease to be someone within the scope of section 39(3), but someone goes on victimising you after that date, or not, but it wouldn't be victimising, goes on subjecting you to detriments on account of your having previously brought a claim, the Act affords you no protection. You've got to be either an employee or an ex-employee under the provisions further else on in the Act, or an applicant, but there's no provisions for prescribing detrimental acts against someone who is no longer an applicant.
My lord, yes.
There's
Because
no
of-
equivalent of section, what is it, 108? I can't remember.
Because, my lord, of course, the Equality Act has specific provision to protect those in relation to work. And so section 39 operates in that restricted and limited
Well,
way.
it'd be a very odd situation, but in a sense, on Claimant's case, this is such a situation where someone who's never been an employee but has been an applicant nevertheless remains in a relationship with the small r, with the person to whom they applied for a job, such that that person is in a position to subject them to detriments months later,
Well,
years later.
My lord, for the
You're
avoidance
saying
of
that's not within the Act.
we're saying A, it didn't happen. There were
No,
no
of course you're saying it
detriments.
didn't happen.
But of course we absolutely are saying it's not within the scope of the Act, and that's what the tribunal judge found.
Yes,
And
but
it was not-
I'm just trying to.
I do
my lady's
understand.
question, I think I may have misunderstood it. Raised this question. She says, "Does the finding you weren't an applicant at the time when these detriments were said to have occurred, is that a complete answer to the claim?" On what I've just been feeling out with you, and subject to what Mr. Siegel, it is a complete answer to
It
the
is.
claim.
That's absolutely right.
And
That's
Mr. and Mr.
absolutely
Siegel
right.
isn't in a anything different because he's nodding.
That's absolutely right, my lord, and that's why.
Yes, that's right. Yeah, I
Yeah.
wasn't expressing myself very clearly. That's what I was trying to get
Yeah,
at.
okay.
And my lord, that's why I took the court to the judgment of the Employment Tribunal, because the way in which the judge describes it, we
Yeah,
say, is
no,
quite helpful.
We see how it fits in. We see how it
Punishes
fits in, but we were just tracking down my
Absolutely.
my point. Yeah.
Yes, so that is the position in respect of section 39. So we were looking at the list of issues, and I was describing the structure of the list of issues. So we've looked at victimisation, and the many, many, many detriments that the claimant relied on in relation to that claim for over a long period, post the period when she was found by the tribunal judge, of course, to be within the scope of section 39, and which we say, of course, is a complete answer. If you're not within the scope of section 39, the tribunal doesn't have jurisdiction. And then we see at paragraph 3 of the list of issues, and this is important, that the way in which the list of issues is framed, the claimant there sets out her direct sex discrimination claim, and she specifically relies on sex by the following alleged detrimental acts, and she specifically identifies all of those that have gone before in respect of victimisation.
It's obviously a typo, it's not 343, it's 334.
Yes.
So in fact, yeah, I'm not being picky, I'm just making quite sure I've understood. She really means by all the previously alleged detrimental acts.
Yes, she means as above.
Yeah.
Indeed. And that much is clear. So she's saying sex and victimisation in respect of the long list
Yes.
for the period during which the tribunal found she was within the scope of section 39, i.e. up to and only up to mid-July 2018, and also in respect of everything that she complains of after that period, but that, of course, failed on the basis of the section 39 decision. So that's where we are, my lord, my ladies, in respect of victimisation and sex discrimination. And we then come to the issue in respect of direct race discrimination. Was the claimant treated less favourably because of an offensive, racist remark made by Mr. Dutoit to her about the conduct of Lebanese managers towards her, contrary to section 13 of the Equality Act, as set out below?
Again, being a pedant, but I think it is actually a bit relevant here. It's not contrary to section 13, it's contrary to section 39. Well, which bit of section 39?
My lord, yes.
Not 39.1, because he's not an employee. Not 39.3, because he's not an applicant.
My lord, yes. And that is a complete answer to the race discrimination claim, we say.
But that's not the answer. Yes, I see. Yep.
Because, just by way of reminder, what the judge found was all the lunches, coffees, meetings, etc. post-dating mid-July 2018 were not arrangements, etc., such that she fell within the scope of section 39. And this date, 29th of September 2020, is of course in that latter period. So whatever was said or done on that date, she's not within the scope of section 39, and that's it.
Yeah.
And my Lord Justice Underhill asked in relation to the remark, what is the detriment? And I said she was upset, and that's set out here. So at 4.1, she refers to, on the 29th of September 2020, Mr. Dutoit informing her the reason she'd not been hired thus far was the negative feedback from her old boss at Barclays, and referencing as the reason for that career obstruction the fact that the senior managers, all Lebanese male managers at the second respondent, held, Mr. Dutoit said, a Lebanese connection with her old boss, which would operate to make it more difficult for the second respondent to hire the claimant in the future. The remark was offensive, racist, and put forward to disguise his involvement in her blacklisting, as well as the main reasons for her blacklisting, which were her protected act and her gender. So it's not particularly elegantly drafted.
Well, it doesn't actually say she was upset.
Well,
Offensive.
my lord, I took from
Yeah.
offensive.
No,
I misspoke. Offensive.
Well, I don't know. Possibly. We all can be offended by racist remarks made in our presence, but not about ourselves or our racial group. Some people are, some people aren't. In a perfect pleading, I think you would say, I found that very offensive, even though I'm not myself Lebanese. There you are. Yeah.
My lord, yes. It's not. What is said here is the remark was offensive, and notably, and put.
Other stuff.
I'm sorry.
Yes, but that
my lady, yes,
that,
quite.
of course, I get that, but that isn't about. I'm not sure that's direct race discrimination.
I'm not sure it is either, my lord.
It's not based on her, on anything to do with her racial.
No, and of course it doesn't need to be, as my lord says. It could be offensive if it was offensive, but and our position is, even if it was said it's not offensive, it doesn't amount to race discrimination, it doesn't amount to victimisation. But for present purposes and for the purposes of the tribunal judge, he put the claimant's case at its highest in considering that the allegations, the remarks she relies on, could amount, if within the scope of section 39.1, to direct race discrimination.
You don't mean 39.1, do you?
3. Well, sorry, no, I do mean 1. Well, I mean, my
just
lord,
to spell it out, 13 defines discrimination, 39 makes discrimination unlawful in certain work situations.
my lord,
1
yes.
being employment, 3 being applicant for employment.
Yes, my lord. So in this situation, we're looking at
I'm not even right about that. There we keep going. Yeah.
with arrangements.
Yeah.
Yeah.
Discrimination, victimisation.
My lord, it is for these purposes for the direct race discrimination claim
Yes.
a question of whether or not the claimant was an applicant. By
Yes.
my lady,
Exactly.
yes.
I was wrong.
My lady,
Sorry.
not at all.
I should have known better. You're
Not at all.
extremely accurate, and I'm not always. So,
I'm grateful.
yeah. So you were right first time.
So the Employment Tribunal judge considered this as part of his determinations in respect of section 39.
Yeah.
It was one of the lunches, coffees, meetings that he refers to. And whether or not the allegation itself can amount to a claim of race discrimination, he didn't engage in that analysis. That would, if the claimant had succeeded at the first stage, have been for another day.
Yeah.
He proceeded on the basis that it could, and quite rightly so.
Finally understood that. It's taken me a while.
Lady, I'm sure that's my fault.
No,
It's that sort of case. However much pre-reading one does, one really has to have one's
Quite.
nose rubbed in it, which you're doing.
Not at all. So those are the points that I wanted to make in respect of my point 1, in respect of this ground. And it's just in terms of where we got to in relation to that point and that claim, we say the list of issues was clearly structured and it was defined the limited ambit of the claimant's race discrimination claim. My lord, my ladies, my second point on this first ground, I hope I'll be able to move more quickly shortly.
And I'm so sorry to interrupt, but at the stage when the list of issues was drafted on behalf of the claimant, I mean, one infers from the language instructed that that was drafted by a lawyer.
Well, Milady, the date of the list of issues is the 4th of June 2021.
Right.
The claimant had solicitors on board, Lawrence Davis of Equal Justice Solicitors. He's referred to wrongly at paragraph 3 of the judgment of the reasons as Ms. Davis, but that's who it's referring to. He was on board, and also, as the court will have seen from the appearances listed by the judge on the first page of his judgment, Sheila Ailey counsel, on the first date, not on the second date, but certainly on the first date, and Mr. Davis was still in the picture on the second date, as identified at paragraph 3.
Could you just remind me of the date of the list of issues?
The
That you,
4th of June 2021,
thank
Milady.
you.
So
And that
pretty
is,
obviously it was done probably by counsel, but certainly by lawyers in advance, basically in preparation for the hearing.
my lord, I'm not sure I can go so far as to say it was probably by counsel,
No.
But certainly by lawyers.
Yeah.
Or whether or not it was done by them, we say it's fair to infer that they adopted it.
Yeah, in a sense, it doesn't really matter, but my lady's right that it has a it takes the rather baggy grounds of claim and perhaps over elaborately, but one sees why you might think it necessary, elaborates it and puts it into a proper legal structure.
My lord, precisely.
Yeah.
Puts
Yeah,
them into a
okay, and
structure.
no, I see why the judge wanted to use it. Yeah.
And Lady Justice King just asked about the date of the list of issues. For your Ladyship's reference, it's paragraph 5 of the reasons. The judge refers to the list of issues there as having been dated the 4th
Sorry, I
of
was
June.
looking at the actual list. For a
I
date.
couldn't see it on there either. And so that's where we find the date.
Thank you.
Grateful. So my second point in respect of this ground, my lord and my ladies, is that the judge was right to approach the strikeout application on the basis of the claimant's pleaded case as reflected in her draft of the list of issues. This court will be very familiar with the principle that a list of issues constitutes the roadmap by which the judge is to navigate his or her way to a just determination of the cases. We've not put it in the authorities bundle.
There's lots of authority. There's some which tweak it slightly and say every now and then, if in an event, there are sometimes circumstances which a list of issues is just a safe guide, but that's where you start from.
It's certainly where you start from, and we say in this case where the claimant was legally represented, there was.
Well, I don't think you need to spend more time on that, obviously. If Mr. Siegel contradicts it, when he can deal with it in reply.
My third point, my lord and ladies, is a very short one, and that is that the judge correctly identified the race discrimination claim at paragraph 73 of his judgment at core bundle page 148. Core bundle 148, paragraph 73. He says there, Mr. Dutoit agreed to meet the claimant for coffee on the 29th of September 2020, and they met at the Ivy in the Park. The claimant covertly recorded this meeting. Mr. Dutoit is alleged to have made a comment about Lebanese connections, which forms the basis of the claimant's race discrimination complaint. So we say there he correctly identified the limited nature of the claim. My fourth point, there is and was no issue in respect of the claimant's race discrimination claim regarding that alleged remark being in time. In order for a claim to succeed past the preliminary hearing, the tribunal had to be satisfied, as we've discussed, first, that it was within the scope of Section 39, and, if it was, that it was in time. But the only issue before the tribunal in relation to the alleged remark was whether the tribunal had jurisdiction under Section 39, given the date of the alleged remark, because the date of the alleged remark was the 29th of September 2020. The first claim was presented to the tribunal on the 1st of November 2020, and so it was plainly within time. And for the court's note, the list of issues sets out the dates on which the claimant engaged in the ACAS process at the top of page 158.
It was in time. It was in time, even having regard to the ACAS process, isn't that right?
Yes.
So that's a bit of a red herring, isn't it?
So
It was only 2
it's not
months.
necessary.
Yeah.
Yes, you're
I'm
absolutely
just
right. No,
anxious
it is.
to
Speed up, yes.
We needn't dot every I.
So only if the allegation was within the scope of Section 39 would the tribunal have had jurisdiction to determine the complaint in respect to the alleged remark. And my fifth point, the Employment Tribunal struck out the race discrimination claim because it related to the period after mid-July 2018 when she was not a job applicant. And that is clear, we say, from the following paragraphs of the judge's reasons. We've looked at paragraphs 3 to 5 of the judgment, but also we say the analysis by the judge is set out from the bottom of page 153 of the core bundle.
That's all. Where's the bit that relates that? And what does this add to what we've already seen from the judgment?
Perhaps not much, but it does deal with everything that happened within that period as not being within the scope of.
Right, and this was within that period, so yeah, okay.
Yes.
Paragraph 107. of the judgment.
Milady?
Yeah.
Yes, that's one of the paragraphs we absolutely rely on. It's 103, 105, 106, 107, 108,
Yeah.
110, 112 and 113.
Yeah.
And so, of course, it didn't matter that the claim was in time because it wasn't within the scope of Section 39. And then I come to my sixth point, which is that the EAT judge misunderstood the position in respect of the race discrimination claim and wrongly allowed an appeal against its strikeout. And I propose to take the court to the relevant passages of the EAT judgment, but I am mindful of time.
Yes.
And so perhaps I can do this by reference to our skeleton argument, which sets this out in quite some detail between paragraphs 25 to 34. The skeleton is at core bundle page 16.
Well, it's quite a lot to read. I mean, frankly, if you're right up to now, the EAT must be wrong. But
Well,
isn't there a more economical way of showing us the past? I mean, I don't mind reading. I've read it before, but I would obviously
well
need to read it again.
I wasn't going to invite
What
the
were you
court to
present-
read it. I was just showing the court where the passages are.
Yes, I see.
And there are 4 particular paragraphs in the EAT's
Oh,
judgment.
I see. I thought for a moment you were doing this in substitution for taking us to the EAT judgment.
Not at all. I'll
No,
take.
okay,
I'll take.
but I agree you can do it shortly
grateful.
because we are getting on. Yeah.
Yes. So the EAT judgment is in core bundle, page 63.
Yep.
Paragraph, I just identify some of the errors that show that the judge
Yep.
misunderstood the position. Paragraph 3, there's a reference to the second sentence. The claimant alleged that she'd been subject to race and sex discrimination and victimisation by the respondent and one of its managers, Mr. Remy Barrett. There was no race claim in respect of Remy Barrett. The alleged remark was, of course, made by Mr. Dutoit. Paragraph 35, page 79. The EAT judge, page 79, core bundle, paragraph 35.
Yeah.
Refers to the meeting on the 29th of September and says those comments were on the claimant's case relevant to the claimant's claim of race discrimination. And we say that is wrong. They were indeed the basis of and the only basis for her race discrimination
If
claim.
this was your best point on it, I'd have thought that was a little bit harsh of the judge, but I take your point.
Paragraph 124D, core bundle 121. In the middle of the longer paragraph, sorry, at the end of the longer paragraph at the top of the page, starting on her case. On her case, it's about 8 lines up from the bottom. She received significant information on the 29th of September about race being a factor. Again, that's a misunderstanding of the limited ambit of the claimant's race claim. And then at paragraph 126, which is core bundle 122 to 123, at ground 4 at the bottom of the page, the judge refers to...
So sorry, give me the reference again.
I'm sorry, my lord. Core bundle 122,
Yeah.
paragraph 126 at the
Yeah.
bottom of that page. Subheading ground 4, adjudication in respect to the claim of race discrimination. For some of the same reasons set out in respect of grounds 1 and 2, I consider that the tribunal erred in not separately adjudicating upon the race discrimination claim. Those grounds, we say, didn't relate to this particular ground of appeal that was before the court. And moving on in that same paragraph, there's reference to information she was given relevant to the potential involvement of racial issues. There is no identification of that important point within the reasons. That is a significant omission. That fact was a highly relevant one to whether time should be extended for the race case.
Yeah.
Lady Quite.
So in other words, this analysis might have been open to the EAT had there simply been a particular sort of claim, but you say, having regards to the list of issues which was drafted by the claimant, this analysis wasn't open to the EAT.
This is a
Lady, yes.
one-off act of alleged discrimination in time.
Quite. Yes, my lord.
Okay.
And the EAT judge refused our application for permission to appeal to this court, and her reasons for doing so, we say, further illustrate her confusion in this regard. And that decision is in the core bundle at pages 130 to 134.
Yeah. Which particular page?
Paragraphs, the page, my lord, is page 131. And may I just invite you to read paragraphs 12 to 16.
Yep.
And we say that that discussion of whether or not the claim was in time was demonstrably irrelevant, since there was no dispute as to the point, and further underlines and emphasises the EAT judge's confusion in this regard. See also, please, paragraph 19, particularly in the middle of paragraph 19 at page C, Core Bundle 132. The judge considered that it was an error not to adjudicate upon the race claim separately. Conversation in which offensive comments were made linking race as a factor to non-appointment to recruitment. The claim in respect of that allegation was agreed to have been made in time. Again, there was simply no issue in respect of that.
I'm so sorry, which paragraph is this? Paragraph
19, my lady, and it's about 8 lines down. The claim in...
I see.
I'm grateful.
Yeah.
And so that brings me to the end, my lord, my ladies, of ground 1.
Yep.
Those were my 6 points in relation to that.
Thank you.
So turning then to the final part 3 of my submissions, grounds 2, 3 and 5, and the EAT judge's interference with the tribunal's decision not to extend time. I propose to deal with this under 5 headings. 1, the pleaded case. 2, to briefly look at the material that was before the tribunal. 3, the tribunal judgment. 4, the relevant legal principles. And 5, the EAT judgment. I'm conscious that 5 is the main part of my submissions, so I may well take some of this quite quickly, if I may. So, part 1, the pleaded case. I just want to draw the court's attention to some of the material that was put in the claimant's pleading. It is in the core bundle, in the supplemental bundle at page 1. And how the claimant put her case in respect of her claims. And by way of reminder, my lord, my ladies, in relation to this claim, we're looking at the victimisation, on our case, the victimisation and the sex discrimination claims. And may I invite you to look, please, at paragraphs 50 to 54.
50 to 54.
Yes, on page 9 of the supplementary bundle.
this was pleaded when? Well, obviously, sorry. This. Yeah, forget it. Sorry, I'll keep my questions for the moment.
So, Lord and Ladies, this is the claimant's own case, as pleaded by her, in respect of the position as she knew it or suspected it in 2018, 2019. I draw attention to
sorry, that's really what I was going to ask.
Well, I was going to draw attention to these specific messages. So the claimant refers to messages, we see this at paragraph 51, text messages between the claimant and her friend Hannah Asayag, who also was a director at HSBC. So the claimant, if your lordship's question was going to be, did the claimant have these messages and when did she have them? They were her own messages. They were between her and another individual. So she had them at the time they were sent or received. So the claimant herself refers at paragraph 52 to Ms. Asayag talking to Eric Dutoit about the claimant, and she pleads, she says, Mr. Dutoit confessed that if the claimant had been a man, upon the same feedback, she would have been categorised as a superstar.
That 51, as now you elucidated it, is in a text to the claimant, which therefore the claimant will have had at the time.
Yes.
There's no reference to a text on the 6th of August. In theory, it might be something that
Well,
either she or Mr. Dutoit told the claimant years later.
my lord, we'll check the references, but my submission to you is that this was part of the messages
Oh, I see.
between the claimant and Ms. Asayag. So
In a way, that doesn't surprise me, but it doesn't say that.
no,
You spared us lots and lots of contemporary documents, but these texts were in bundles before the tribunal.
they were. Yes, they certainly were. And the claimant was taken to them in cross-examination.
So 6th of August, there's a message between the two friends, presumably from Hannah to the claimant, saying, guess what, I bumped into Eric on the tube. This is what he said.
Something along those lines. We'll dig out the reference, but yes, my lady.
Well, you'll dig out the reference in the sense, you'll confirm it was a text.
Yes. I have just confirmed that. We'll just double checking the position.
Yes, okay, so that's 52.
And between September 2018 to January 2019, Hannah Asayag tried to understand exactly what had happened and why the claimant was not hired. So that all suggests that this is the picture as being related to the claimant contemporaneously by Hannah Asayag.
Again, that's not clear from what.
Well,
it's a reasonable inference, but it's not what is said.
my lord. But at 54, we are taken to a text message. So at 54, the claimant refers to a text message from Hannah Asayag to her on the 5th of January 2019, which the claimant has translated there.
Yep.
And the claimant's translation of that text message.
That's a reference to the proceedings.
Yeah.
Quite. Then the guys are afraid. We say it's been inferred that that's a reference to the guys at HSBC. The guys are afraid because the guys at HSBC, hear the feedback and because there are proceedings going on. And the proceedings going on are the proceedings as between the claimant and Barclays. So she's in discussions with Hannah Asayag. There's reference to sex. She's a woman. Had she been a man? There's reference to the guys at HSBC being afraid because there are proceedings going on.
I see why you want to run it in, but I know time is short. You've got the point.
Lord, I'm grateful. So that is the picture part of the picture that the judge had before him.
So it doesn't refer to.
He doesn't refer expressly to those
No.
text
So
messages.
your case presumably is that he alludes to it because he's basically saying
Yeah.
she didn't know,
Yeah.
she didn't find out anything
Yeah.
really
This is
serious
what
or-
he had in mind, and you'll
Precisely.
say you don't have to put into the reasons everything that's in the evidence. You just assume you had it in mind. Yeah, okay, got all that. Right, so that's the pleading. More in the pleading, or are we?
Well, there is a lot more in the pleading,
well,
but
any
I'm,
more in the
I'm
pleading
conscious of
relevant to
time.
this point?
I'm conscious of time, so I'll just move on. But it does bring me neatly to that the
Yeah,
second
okay.
the second.
But I think if you're, it might help, sorry to interrupt, if you could just give us a list of paragraphs in the pleading which support the point you're
Yeah.
making based on these paragraphs. And we don't have to read them now, but if you could just give us references. If
I
you,
mean, if this is really the only point which is as explicit as this is, I can see why you don't want to show us any more that it's just guesses and inferences. But if there's any more solid like this, we'd like to see it because it's rather important.
This is the high point.
Okay.
This is where it's absolutely clearest.
Yeah.
Where there's references to sex and to
Okay.
victimisation. So then just turning to my point two, part two, which is the material before the judge. I'll just touch on that very, very briefly.
Yeah.
Just want to give a flavour of the volume of material that the judge had before him at the 2-day open preliminary hearing. I do it by reference to the tribunal's judgment at page core bundle 137. He refers at paragraph 19 on page 141. Paragraph 19 on page 141 to the extensive hearing bundle of over 1225 pages and a supplementary bundle consisting of 99 pages.
Yeah.
Then he says he considered documents that were specifically referred to during evidence and submissions. That bundle, of course, included the pleadings, including the claim that we've just looked at. As to witness evidence,
Just pausing there. The text, there's pleadings, but the text messages were also in the bundle.
they were.
And I think you told me that the claimant was cross-examined on those text messages.
Yes.
Okay, carry on. You're about to say about witnesses.
For clarity, she was cross-examined by reference to the text messages in the general sense, but I can't standing here now say specifically which of those she was taken to. Though, well, that's probably as far as I can go at this stage. We can try and check the notes.
sorry, Susan, what do you mean by that?
We sorry, may I just take a moment?
Yes, of course.
She was cross-examined by reference to specific text messages, but we're just going to double check that it was included those
Have a
two,
note of the hearing.
which we will check, yes.
Well, frankly, one would expect
My lord,
that the ones, if you're cross-examined on the text message at all, it'd be odd if it was not cross-examined on the ones referred to in the pleading.
my lord, yes.
But still, I agree you ought to check.
At page 139, core bundle page 139, there's reference to the evidence and witnesses.
Yeah.
Paragraph 6, all witnesses gave witness evidence under oath, subject to cross-examination and questions from the tribunal. 7, the claimant prepared a lengthy witness statement. Then there's reference to Mr. Longmore, who the claimant called, that was in respect to the section 39 point, and Lauren Collett, who again was relevant to the section 39 point, that's paragraph 13.
So the only relevant evidence on, as you would expect, on the time point would be explaining the delay effectively, would be the claimant.
Yes,
And she gave evidence and was cross-examined
yes,
partly on the section 39 point and partly on the time point.
my lord, yes.
And we don't have her, and I'm not complaining, We don't have her 449 paragraph witness statement, or do we?
We have part of it in the supplemental bundle that relates to time limits.
Okay, embarrassingly, I haven't read that, but
Not at all.
please don't take us to it unless you were going to anyway.
I wasn't particularly planning to
No,
take
it's up to you, of
to
course.
it.
And it's always dangerous anyway for an appellate tribunal to look at a witness statement without also seeing the note of the oral evidence.
My Lord, perhaps we'll check over the adjournment whether or not there are any particular passages to refer the court to. There was also, as one sees from paragraph 26 to 27, the witness statement from the claimant in the Barclays litigation, and that refers to paragraph 450. So that lengthy witness statement was also before the tribunal. And the paragraph 104 of the judgment, the tribunal judge refers to,
I'm so sorry to interrupt.
not at all.
Paragraph 27 that witness statement is the reference towards the end of that protection to a female employee of HSBC reconfirming something to August 2018. Is that a reference to the text we've just been looking at? Or am I reading too much?
Milady, yes, it is. She, Hannah Asayag, was the individual who introduced the claimant and forwarded her CV.
Okay, so that is a reference. Okay.
It is. And I haven't taken the court to it, but there is a chronology, an appellant's chronology that's in the core bundle that we updated with some cross-references, and I think that might refer to this particular point in case that's helpful from a referencing perspective. Paragraph 104 of the judge's reasons, page core bundle 153, the judge refers to having heard extensive and oral submissions and written statements opening and closing. And not at all, milady. Paragraph 104, core bundle 153.
Was the structure that all the evidence was in the first day and the submissions in the second, or did some of the evidence go into the second day?
Some of the evidence went into the second day of September. So it was the claimant on the first day. So I cross-examined the claimant on the first day.
Yeah.
Mr. Longmore, her witness, who wasn't in fact an expert, I did not cross-examine.
Yeah.
And then on the second day in September, the claimant cross-examined Lauren Collette, the respondent's witness on the section 39 point. And we made submissions. And there was various written submissions as well along the way, including in particular on section 39. So we were looking just, I was just touching.
I'm going to be embarrassed for how carefully, I say from the start I hadn't read anything in the supplementary bundle you referred to, but we haven't got the written submissions, have we? In the tribunal?
No.
Just looking at the index.
No.
Okay.
The court has the skeletons from the EAT.
Yeah.
We can provide them if that would be helpful.
Well, I don't know whether I think I won't ask for them straight away. But wait, at the moment we haven't got them.
No. and my lord, there was an authorities bundle, but also at paragraph 4 of the judgment, core bundle 139, the judge refers at paragraph 4 to the claimant having provided further 49-page written submissions after the hearing, which hadn't
Yes.
been directed. So there was a great amount of material that was before the employment judge.
So again, just to be clear about this, there were written statements drafted by you and your team in opening, and also from Mazzali in opening, and then the closing submissions, again, written from you and your team, and from the claimant. But in were the closing submissions after the 7th of September?
So there were some in the intervening period. The judge asked for some help with section 39.
Yes, I see.
And so there were some submissions in respect of that.
Yeah.
And then the claimant also put in some submissions after the second day of the hearing.
You put in written closing submissions.
I need to double check that.
So I see, okay.
My lord, I think that I'll just need to double check that.
Better check. Yeah.
May I
Okay.
just say, for clarity, in respect of the claimant's opening submissions,
Yeah.
I don't believe it's accepted by the claimant that Ms. Ali produced those.
I'm sorry, I just assumed it was Ali. It
I-
doesn't matter. It doesn't, but you're right to pick me up. Carry on.
My lord, I'm very conscious of,
Well, I know, but
Time.
since you're on the question of what materials before the judge,
yes.
quite often in these cases, I'm not saying this is one of them, it's helpful to see what the case was as put by both parties in front of the judge. But this quite respect your and Mr. Siegel's judgment, this isn't one of those cases. Yeah. Okay.
Then in respect of my point 3 is the tribunal judgment.
Yeah.
But as I say, I am very conscious of time, and in relation to the dates and the particular facts, and perhaps I could invite the court to look at my chronology, where we identify specific findings along the way in terms of the key dates, and perhaps by reference to that. My lord, I'm conscious, my ladies, in terms of timing, that I'm unlikely to finish by 1 o'clock if I'm going as I currently am, but I wonder if you'll be best assisted by me jumping
Well,
ahead.
you've got to cut your coat according to your cloth. We are normally tolerant of the appellant in a one-day case going slightly after lunch if necessary, because they have to cover ground just introducing us to the case. And it'll be quicker for Mr. Siegel, but we won't want you to go much over. I think it would be healthy to see if you can finish by lunch.
My lord,
Only you know what points you want to go take
Yes.
us to.
and so,
If it would help, it's obvious that probably the central point of the case where we need to see documents is evidence before the judge about when she knew she had, to use the Affalabi language, an arguable case. And you have just shown us something in the pleading, which you are no doubt going to rely on from that point of view. But I wouldn't go short on those sorts of points if there are more.
those are the key points in respect of whether or not
Well,
she
the ones
has-
you've already shown us. Yes, I see,
Yes.
okay.
I think your junior's got a document for you.
And my Leonard Junior is helpfully reminding me about the claimant's witness statement in the Barclays proceedings.
Yes,
Part of that witness statement is referred to by the judge
yes.
in his judgment, and we'll see if we can get copies of the part that's not in the judgment.
Only if you want to rely on it, but
But it refers specifically, and for the court's note, paragraph 450 of the claimant's Barclays witness statement, December 2018.
Is this a passage that is in the bundle?
The first half is in the,
Well, I
It's
don't want you
quoted
to
by the
refer us to
tribunal
anything that
judgment.
isn't quoted by the judge. I mean, you may, but you must do it properly. You must get us a copy and show it to Mr. Siegel,
my lord,
because
yes, thank you.
he's entitled to assume, and we are entitled to expect that everything you're going to rely on is in the bundle.
Yes, of course, my lord. So in respect of the tribunal's judgment, those are the key passages that I wanted to show in terms of the dates on which
Yeah.
the claimant certainly had, we say, at least in our enough information.
Well,
to be
sorry,
suspicious.
this is the key point of the case. Where in your chronology?
Well, my lord,
I thought you said you were using the chronology as a shorthand.
the chronology is a shorthand in respect of the development of the key dates between the 2018 and 2019 conversations that we looked at in the claim and the date on which the claimant presented her first claim.
Yeah.
So one can see from the chronology all the steps that took place. Well,
Okay,
some of
but
the
none of
steps
those
that
really
took place.
matter, do they? I mean, the focus of inquiry is effectively your case is, and the judge's finding was that she should have started proceedings in late 2018,
Yes.
and I'm not suggesting it's quite as simple as this. There have to be other points you may have to take us to. The question is whether the evidence in front of him was a sufficient basis for him to find that she knew all he needed to know to bring proceedings then.
Yes.
And it doesn't really matter why she didn't bring them in 2019 or earlier in 2020, because she's already in trouble.
My lord, yes. Perhaps I can take you to the judgment where the judge deals with his analysis
Yes.
of that just and equitable extension. Page core bundle 155. See there the heading just and equitable extension.
Yes.
The judge specifically refers to the DSARs that the claimant had submitted, paragraph 119. And of course, she'd submitted DSARs on the 10th of October 2018, and in June and in November 2018.
Yes, but we don't know what she was asking for, and we haven't seen what she was told. So that doesn't help us very much, does
Well,
it?
my lord, the judge does refer to, if I can take your ladyship's back to page core bundle 142.
Yeah.
To take you to the earlier page, the bottom of paragraph 24. The claimant has submitted 8 separate DSARs to the respondent, so that's the bank.
Yes.
And this is probably a convenient moment to remind the court that by the time of this open preliminary hearing, although the claimant had initially presented her first claim against the bank and Mr. Barrett,
Yeah.
she withdrew that claim against Mr. Barrett and it was dismissed. And so the tribunal was only concerned with whether or not it was just and equitable to extend time in respect of the claim against the bank.
Yes.
So we say, of course, she didn't need to know who was doing what or who was involved in respect of any claim she brought against the bank thereafter. So in respect of the DSARs, paragraph 24, she submitted 8 DSARs, and the judge refers specifically at the top of 142 to what the claimant was seeking in respect of 2 of those DSARs. On the 10th of October 2018, she was specifically asking about there have been communications between HSBC employees and Barclays employees, of which the claimant is the subject. And also then reference to HSBC made the decision not to hire me in 2018. So the claimant is asking questions, seeking documents and information in the context of her knowledge, her belief that there are communications between HSBC.
Yes, but he doesn't
And
know what they were.
No. Turning then to the section on just and equitable extension, page 156. The judge refers to the claimant's submission at paragraph 121 that her claims against HSBC only crystallised after the 26th of August 2020 and 16th October 2020, when she received the outcome of the HR investigation and the following DSAR reply, which included handwritten notes. The judge concluded, "I do not accept this. The claimant's contemporaneous expressions and actions wholly undermine her contentions in this regard." That, we say, was a finding that he was entitled to make based on the evidence he had seen and the evidence that he had heard from the claimant. He says the claimant was fully aware of the elements of her claim for non-appointment to a role in July 2018 due to bad reference from Barclays. And he goes on, she proceeded with claims against Barclays, but strategically opted not to pursue a claim against the respondent in the hope of securing employment with them if another opportunity arose in future. So he found as a fact that she knew there had been bad feedback from Barclays, bad reference from Barclays, and yet she chose to continue going after Barclays and not HSBC.
But she doesn't. On what he says here, you've shown us that he had material that went further, but on what he says here, he doesn't say anything about the bad reference, knowing that the bad reference was, or there was reason to believe the bad reference was because of her sex or because she brought a claim.
My Lord, that's right.
That's what he ought to, that's really what he ought to have said.
My Lord, it would have been better and clearer, but we say when one looks at the principles of analysing tribunal judgments, it was good enough. And particularly when one looks at the judgment as a whole and this analysis as a whole against the findings of fact that come earlier in the judgment and also in the context
That's an easy
of
thing
the
to say,
material.
but are there specific findings elsewhere in the judgment which put flesh on those bones? I haven't read so much the bits about which is directed to section 39 issue, but in the bits I've read carefully, I haven't found anything to suggest that she knew at the time, findings by him that suggest that she knew at the time that it was because of it, or might have been because of the fact she brought proceedings against Barclays or because she was a woman.
My Lord.
She brought a particular type of proceedings against Barclays.
I'm sorry, my lady.
Well, or that she had brought discrimination claims against Barclays, because you don't have a victimisation claim unless you've done a protected act, and bringing general proceedings generally isn't enough.
The claimant's own case, I'll be corrected if I'm wrong, is that she was made redundant after returning from maternity leave, and so she had told Mr. Dutoit that fact, and so Mr. Dutoit, knew.
There's no findings about this, but what does it? If we have the claimant's witness statement against Barclays, even if we don't have the pleadings, I don't think the judge had the pleadings, did he? He says he didn't have the pleadings, but he did have the witness statement.
Yes.
Presumably, if it was a sex discrimination claim, that would have been apparent somewhere from the 449 paragraphs. But
Yes.
we haven't got any of that.
My Lord,
unless it appears in the short extract the judge quoted, which I don't think it does. Let's just have a look.
The real thing is, when did she know that HSBC knew that she brought discrimination claims against Barclays?
Milady, our position is she didn't need to know that they knew. She needed to suspect.
Well, it's a tricky point that, which none of the skeletons really focus on, but the nearest we get in the authorities is Affalabi. But I would guess the test is perhaps quite like the test for personal injury claims under the Limitation Act, or maybe general now, rather odd test about whether you knew enough to make it sensible to bring a claim.
Well, my lord, my ladies, if the claimant had, having received these text messages from Hannah Asayag in 2018, 2019, presented a claim to the Employment Tribunal of sex discrimination and victimisation against HSBC, those claims would not have been struck out by an Employment Tribunal.
No.
She could have, and we say, and the tribunal judge, we say, found, should have brought her claims earlier than she did in order to pursue them.
It's sort of unknown for employers to apply to strike out victimisation. There's nothing in the claim form that shows that the employer who's accused of victimisation knew the nature of the claims being brought by the employee.
But my understanding is that you say that the text meant that the text messages, or the statements based on text messages, show that HSBC, because it was HSBC to whom she was speaking, who was sending, knew that she had brought proceedings against Barclays. They don't, because there's a reference to un procès. It isn't clear that those were thought to be on the basis of sex discrimination.
My lord, I'm relying on those text messages not in respect of what the bank knew, but in respect of what the claimant was being told and what she
know,
knew.
but what the claimant has got to know about what the bank knew.
Well, my lord,
Up to a point.
Quite, my lord. In order to present a claim of discrimination or victimisation, one does not need to have a complete puzzle. The jigsaw does not need to be complete. The claimant had enough, or the judge was entitled to find, the claimant had enough, knew enough in 2018 to have presented claims. He had a wealth of material, he heard all evidence, and he made findings. She knew enough, and what she knew later, and I'll take you to this passage, what she found out later, she was fully aware enough to have brought claims, and those were permissible conclusions by the Employment Tribunal judge. She didn't need to know that that HSBC were aware of Protected Act. She didn't need to know that the reason that she, on her case, wasn't hired was either because of sex or in retaliation for by way of victimisation.
Depends what you mean by no. But I mean, in the sense you're slightly underselling, the passage in the pleadings gets you 90% of the way there. I think the only element that you're, well, Mr. Siegel will, I'm sure, make submissions, and it may be that I would be dissuaded from that. But the only thing I think is not clear from those conversations which she had in 2018 is that the bank knew that the proceedings she brought against Barclays were discrimination proceedings as opposed to ordinary unfair dismissal, which I think I'm right in saying wouldn't give rise to a victimisation claim.
No, that's right. There isn't a specific finding to say she knew that the bank knew that she'd brought proceedings within the scope of the Equality Act, but we say that's putting the case too high.
Yes, in India. It is an essential element in the cause of action.
Well, it is an essential element, but it's not necessary in order to,
I mean, she, of
Start
course,
seeing-
herself knew what kind of claims he brought.
yes. But also, my lord, there was also the sex discrimination claim. So much of the focus has, of course, been on the victimisation claim, but none of this is an excuse. Her knowledge or lack of knowledge would in any event be an excuse in respect of the sex discrimination claim, and it's certainly important to bear that in mind. But we say the tribunal judge was entitled to reach the decision on the basis of the wealth of material in front of him that it was not just inequitable to extend time, and the burden, of course, was on her, and she had not satisfied the judge.
Okay, just so you can focus your submissions where they're most needed. Maybe actually you said all you can say, but that's important to know. The reasons, the expressed reasons in the Employment Tribunal are unsatisfactorily specific about what she knew about what the bank knew. They're really just almost conclusory, not quite, but there's not much more apart from what we see in 121. You are entitled to say, because of those authorities that say there was lots of evidence, everyone will have known what the evidence was, and it's perfectly clear what he was basing his conclusion on. And that's why, rightly, you wanted to show us the materials before the judge and what he said elsewhere in the judgment. But we haven't had any specifics apart from those very important passages in the pleading. Is there anything else in the material before us that helps fill that gap in the jigsaw?
My lord, may I take the court to paragraph 42 of the judgment, page 144 of the core bundle. That is in the tribunal's judgment, reference at paragraph 42. The claimant and Mr. Dutoit met for coffee on the 18th of May 2018. Mr. Dutoit indicated that he would like to progress the claimant's hiring. At this meeting, the claimant explained to Mr. Dutoit that she was in a dispute with her former employer, Barclays. I accept that it doesn't say what was the nature of the dispute in that.
Doesn't even say it was legal proceedings. I mean, it's pretty common when people, especially in my experience in high-end city banking, when you leave your employer, there's nearly always a dispute of some sort. Now, it may be that actually the judge here is summarising some evidence which the claimant gave much more explicitly, and then you could show us that evidence and show that this was just a shorthand for material that was before him. But you haven't done that yet.
My lord, just carrying on in that part of the judgment, the judgment at paragraph 44 notes that whilst the claimant discovered some of the detail of the feedback that was being sought on her when she received the DSR response in 2020, the content of the feedback was not inconsistent with her knowledge and understanding that she had at the relevant time when her appointment was not progressed in 2018. And then it refers at the bottom of that paragraph to, it's clear that despite the negative feedback, Mr. Dutoit was actively progressing the claimant's candidacy, which was being and considered against other potential candidates. And then it goes on in respect of what then happens in respect of recruitment. And then at paragraph 54, there's reference to there was an impasse. The claimant sought a directed GCB3 role, but the respondent's practice was she couldn't be promoted on appointment. Mr. Dutoit still tried to make appointment a possibility, even with the negative feedback.
But all this shows is there was negative feedback. That isn't the issue. We all know that.
Lord. Jumping forward to the analysis in respect of just and equitable extension. Paragraph 105, sorry, 115 at page 155. The claimant asserts, as she did in her earlier Barclays claims, that the Equality Act 3 months is such that the just and equitable extension should be exercised liberally, etc. So the judge had regard to what the claimant had said in her witness statement, seeking to extend time in her Barclays witness statement. He correctly directed himself in respect of the law at paragraph 116.
But I mean, these points don't really deal with the point with which my law is concerned, which is what findings did the make that when she knew enough to bring her claim. This is all part of the background. She knew about the qualification, she knew about time, and so on and so forth. But it's not really relevant to the key issue, is it?
M'lady, I recognise that. At paragraph 121 is where the judge deals with what she knew, and that's the passage I've already taken the court to. The fact that he concluded she strategically opted to pursue a claim against the respondent, not to pursue a claim against the respondent. And at 122, the judge finds as a fact the basis for the claimant's claim was apparent from an early stage. So that is, I submit, the finding in respect of.
Yeah, I think it is, but it's very elusive and high level. It's really the same. She was fully aware, it says in 121, fully aware of the elements of her claim for non-appointment. Her pleading, the elements of her claim are victimisation, sex discrimination. And again, the basis for claim. Now, I accept you have a finding, but you have no analysis of how he gets to that finding or what evidence he relies on.
And my lord, that's where we rely on the authorities that say that he sets out enough here. We submit.
Well, that would be more compelling if we saw the material he had available to him, and you'd be able to say, look, he had all this. It's perfectly obvious what he had in mind. And that might get you home, but we haven't seen much. We've seen the particulars of claim, and that's a good start for you. But that's really all you can show us.
My lord, in terms of what we have before you in the bundles, that's the high point, and we say that that's relevant material that the judge obviously had before him. But he also
I see that.
Carrying on in this judgment, my lord.
Can I just mention something now?
Yes, of course.
The complication is. One does need to look at the nature of the challenge in the EAT. We'll come back to this in a minute. But if it was a meek challenge, then you would be saying, well, the reasons are adequate because look at all the other material he had, and you would have produced to the EAT, not I hope all the evidence, but anything that helped on this point. And likewise, really, if it was said to be a perversity challenge, you would have said, well, both parties would have had to say in the case of a perversity challenge, here's the evidence, the totality of the evidence. On that basis, it was not open to him to make a decision. So did the EAT have more than we have?
I'm looking to check that Miss Banton agrees with me, but I don't believe that there was more before the EAT than your lordship and ladyships have in terms of that material.
I'm told that my instructing solicitor had correspondence which ensured that all of what was before the EAT is before this court. So there's my instruction.
Yes, I see.
Thank you.
Okay. So EAT and everything. We have, but nothing else.
Well, I don't know about that. You
Oh.
have everything they have. I don't know whether there's additional
Oh, I see. Oh, I agree. I put it in the
bundle
not
for
really the
this
tougher
court.
way around. Yeah. Obviously, the EAT didn't have everything we have because some of it's since then, but we have everything the EAT had. Okay.
And my lord, along the same lines, the judge continues in his judgment. At paragraph 123, we've looked at the late disclosure did not change what the claimant was already aware of in 2018. This is the end of paragraph 123. Namely, that negative references had been given, which she sought to address.
But in a sense, that's bad for you.
Yes.
It's only that negative references have been given.
My lord, we say that
Now, in fact, and as a reference to email of the 5th of July, I've tried to find what that email was. There's no findings about it in the judgment. I think, funnily enough, the EAT says a bit more about it.
my lord,
Are there findings about it in the judgment?
the email of the 5th of July is an email that the claimant sent with some further feedback.
To get some further feedback.
It's paragraph 44 of the tribunal judgment.
Oh,
Core bundle 144. The claimant provided further positive references.
positive references.
to
Thank you.
seek
Sorry,
to
I must
address
have
the
missed that.
negative feedback.
So that's 44. Yeah. Well, that doesn't really advance. That just shows she'd had some. She knew there were negative references, which is not an issue. And she sought to answer it by saying, "Here are some good references."
Yes.
So what? Doesn't go to the heart of the matter, does it?
Well, my lord, she had brought claims against Barclays, and she knew that there was negative feedback from Barclays that was being provided to HSBC. And such negative feedback could, of course, include, and we say it's to be inferred, although I accept the tribunal judge didn't set this out, include you don't want to recruit her, she's brought proceedings against us, for example.
But even that wouldn't be enough, would it?
But we brought discrimination.
She's brought
proceedings.
discrimination proceedings against us, my lady. But we say, I accept that the judge doesn't spell it out in his judgment. We do know that he sets out the nature of the claims. Well, the particulars of
Sounding to me like something.
my lord, in the particulars of claim in the supplemental bundle, the claimant had set out the nature of the claims that she'd brought against Barclays. If I can take you to supplemental bundle page 1.
If you like, but that doesn't help, does it? We know the claims against Barclays were discrimination claims.
Yes.
She obviously knew that because they were her claims. Did HSBC know that?
I don't have any material to put before you, my lord, to establish that HSBC knew that in 2018. The findings of fact that I referred to refer to Mr. Dutoit knew that she was in dispute.
Yeah, well, I know you've showed us all that.
Sorry, my lord, may I just take a moment? Lord, I'm conscious of the time. We're at page
We are
one.
on the most important part of the case, but yes,
We are,
okay. But
we
you've,
are
you've
on-
said as much as you can say. Yeah.
Well, looking at page 156 of the core bundle,
Yeah.
the judge has set out their reference to 124, the disclosure points that the claimant was referring to. They are in fact DSAR points and responses to DSARs rather than actual disclosure. And at 126, he refers to the personal circumstances that the claimant relied on to explain the delay between June and August 2020. That's set out in her witness statement,
Yeah.
which is in the supplemental bundle.
We've seen all that.
And
yeah.
then we say, crucially, the judge says at paragraph 127, I am unimpressed with the claimant's reasons for not bringing a claim against the respondent sooner. The burden of proof was on her to satisfy the judge that it was just and equitable to extend time.
Yes, I read that, but perhaps wrongly, as being simply a continuation of the points made about 126. But you think that's it's meant to be more general?
My lord, I submit that it is. It is the conclusion.
Not really engaging with the difficulties that it's described in 126. Because it says, well, does that matter? Because nearly 2 years after she knew what she needed to know.
But if you can get over the first hurdle, this isn't a problem for you, because the judge himself says these difficulties occurred 2 years after the action plain law, and if the judge was right or entitled to find that she knew everything she needed to know in late 2018, then the fact that she had difficulties in mid 2020 is neither here nor there. What about the previous 2 years? I think that's really the judge's point of 126. But that's why I keep focusing you. But I don't want to go on about it. You've said what you can say about it on the basis of his finding that the claim could have been brought in 2018.
Yes, but
You've addressed us on that, as you said, time is running out.
my lord, yes, but and over the page at 157, the judge finds at paragraph 128 that the claimant has at all material times had the resources and capacity to secure legal advice to bring a claim, but did not do so timelessly. So
That's beside the point that we're really interested in, isn't it?
well, save my lady that if the claimant suspected in 2018 or had basis for suspicion in respect of claims against HSBC, for example, on the basis of the messages from Hannah Asayag, she should have sought advice in respect of whether or not to bring claims against HSBC at that time on a protective basis. That was part of the context in which the tribunal judge declined his wide discretion to extend time.
Well, it doesn't really matter whether she was well advised or whether she had access to advice or not. If she didn't have enough material, then end of story. If she did have enough material, she should have brought the claim.
And my lord, the question is, what is enough material
Yeah, well,
in
I
that
know,
context?
that's what we've been looking at.
And I submit that to suggest that she needed to know that HSBC knew that she'd brought a discrimination claim, either, in other words, knew of a protected act, is putting it far too high.
Yes, I see. No.
Not least because, of course, a protected act can be based on belief of a claim rather than there had in fact been a claim. And I accept that there's no findings.
I see that, but
in
that's a bit
respect
of a red
that.
herring in this particular case, because she knew, HSBC knew there'd been a claim because, as Hannah has already been told, it's only the nature of the claim.
Yes. And we
And you could say, well, what kind of claim is it going to be? Who's going to bring up? Well, not really sure, but who knows?
well, particularly in the context where on her own case she's been made redundant after return from maternity leave, and there's the reference to a woman.
Would the HSBC know that? They know she was a woman. They might not know she'd been dismissed after her return from maternity leave.
I'm reminded that I cross-examined her specifically on in relation to that. That she.
Well, that's great, but we haven't got
don't
any.
have the
You
notes.
said that. We haven't got any notes of the evidence below. I mean, if we had all the material below, it might well be possible for us to say, look at all the stuff for the judge, perfectly clear what he based it on. But we don't. You tell us now, it's not even, I'm sorry, not being rude, I'm just
I understand.
identifying the difficulty.
Yes, my lord.
Okay.
And at paragraph 132, just to finish off this reference to the judgment, the judge says that he's considered all of the circumstances and submissions, that the balance of prejudice favours the respondent in refusing to exercise his discretion, and again that the claimant has not convinced him, the claimant whom he heard from, seen evidence at the open preliminary hearing. So he had and seen the claimant, and we say reached a permissible conclusion on the basis of all of that material.
No, you're going to show us where the EAT went wrong.
My lord, yes.
Well,
I was on section 4, legal principles. I'll take those.
Just tell us which ones you say they are.
Well, I'll take you to the principles without turning up the authorities.
Okay.
7 points of principle in respect of the tribunal's exercise of its just and equitable discretion. First, Parliament has chosen to give the tribunal the widest possible discretion as to whether or not it is just and equitable to extend time pursuant to section 1231B.
Yeah, well, that's pretty obvious.
Second, the discretion is to be exercised by reference to all the circumstances of the case, but does not mean the tribunal must hear the substantive complaint before it decides whether to extend time. That's Appellant at paragraph 30. Third, that exercise of discretion by a tribunal is a question of fact and judgment, cast in paragraph 32. Fourth, as part of that exercise of discretion, tribunals are required to carry out a balancing exercise which assesses the prejudice each party would suffer if an extension were granted.
Yeah.
Fifth, the burden of persuading the tribunal to exercise its discretion to extend is on the claimant.
Yeah.
Seventh, there is very limited scope for
Sorry, I thought that was
challenge-
fifth. What's sixth?
Sorry, sixth, there is very limited scope for challenging the tribunal's exercise of discretion on appeal.
Yeah.
And this court will be very familiar with the principles in relation to that, so I
That's
don't spell
that's
that
the
out
Abatawi case. Yeah.
in more detail here. Seventh, the relevant question for the appeal tribunal in determining whether a tribunal was entitled to find it just and equitable is whether there was material on which the tribunal judge could properly exercise their discretion, not whether the appeal judge agrees with the tribunal judge's conclusion.
Yeah, of course. I mean, these principles, I don't blame you for reminding us of them, but they're all classic principles whenever you're dealing with a discretionary evaluative judgment. But if it is based on a completely false factual basis or is not sufficiently explained, it's still challengeable.
Lord, yes.
All that's going to happen if you lose this appeal is it's going to go back again. A terrible thought, but it is. It's going to go back again, and the tribunal is going to look at it. If you're right, hear pretty well all the same evidence, look at pretty well all the same material, but do a better job of giving reasons. It's a pity, but there we are.
My lord, my lady, those are the propositions I wanted to refer your lordships and ladyships to in relation to the just and equitable discretion. And then, although the court will be very familiar with this, the points of principle in relation to the approach of appellate tribunal or court, and by reference to the case of DPP and Greenberg.
The issue for us is really just the same as the issue for the EAT. We look at the ET's judgment and we see if there's any error of law in it. And if we think that there isn't, then the EAT was wrong to overturn it. We don't have an elaborate analysis of our approach to the EAT's judgment. The focus is all on the ET's judgment.
Yes.
Yeah. Okay.
Turning then to the EAT judgment. This is set out as part of grounds 2 and 3 of our skeleton from core bundle page 25, paragraph 35 onwards. What we've done there is to set out the errors identified in our skeleton by reference to the EAT judgment. And may I invite the court to take up the EAT judgment and core bundle 119.
Only because you say you're worried about time, it's probably what you're going to do. Isn't the essential exercise you have to do to go through para 124 and
Yes.
shoot down each of the, or as many as you can, of the reasons the judge gave?
Yes.
Yeah.
And my lord, we've done that very careful exercise in detail in the skeleton
Yeah.
by reference to the principles that I've set out
Yeah.
that the court will be very familiar with. But what I was proposing to do is to take them, rather than take them in the order in the skeleton, take them just in the order they appear in the judgment
Yes.
for ease.
Yes.
So starting at paragraph 124, core bundle 119, the judge there says, in respect of the balance of prejudice, whilst the judge stated at least 3 times that he considered the prejudice each party would suffer, he doesn't identify it. And also he did not identify or appear to consider the significant prejudice. But of course, the judge absolutely did do that in the very next paragraph, which the EAT judge finds troubling. Whereas it's specifically the point that public policy dictates such matters are heard. That is,
Far from being troubling, it shows that the employment judge did what he should have done.
Yeah.
well, they did quite, yes.
Okay.
Not the EAT's best point.
Well, I'll move on then, rather than show you the other references to prejudice in the tribunal's judgment. 124B2. The EAT judge said there was no recognition that disclosure had not taken place in the second claim, but the time point was only concerned with the first claim, not the second claim. And there was, of course, no extant appeal against the refusal of the disclosure applications. 124(3)(b)(3), while the judge referred to the authorities which emphasised the fact-sensitive nature of discrimination claims, he did not apply those principles, and simply no basis for such criticism in light of the correct approach to be taken.
It's a bit of a non-point.
Yeah.
My lady, yes.
The real issues are.
Yes. 124C, the judge failed to identify or evaluate the risk in determining the question of whether to extend time without having heard all of the evidence. Surprising and erroneous observations for an EAT judge to make in circumstances where the PH had been listened specifically to deal with a time point.
Yeah.
And of course, at a preliminary hearing determining preliminary issues, one doesn't hear all the evidence or the substantive evidence. And we say that that approach and that criticism, which was unjustified, infected the EAT judge's judgment and her approach, because she considered that there ought not to have been an OPH in the first place.
Yeah.
124D at the bottom of page core bundle 120.
There might be a confusion here between striking out a discrimination claim and
Yeah.
bouncing it out on a time point.
My lady, that wasn't the point I was going to make, but the judge there says, I consider the judge failed to take proper account of, so decides herself what weight the tribunal judge ought to have given to these factors, and goes on to say at the top of page 121, impermissibly, 4 lines down, and that had played a part in the decision not to progress her candidacy. So seemingly a finding of fact by the EAT judge that was not permissible and not open to her. In the middle of that paragraph, page 121, the claimant says she did not have any information about Mr. Barrett's role within the respondent as revealed by the documents. But of course, she didn't need to know about his potential involvement in order to pursue a claim against HSBC. It would have been a good point if the claim was against Mr. Barrett personally. He had initially been pursued, but then she hadn't pursued that claim. So what he knew or didn't know she didn't need to know the identity of any alleged victimiser or discriminator to pursue a claim against the bank.
The truth.
Oh, sorry.
I think with my lady and I make exactly the same point, but I'll pull rank. There's lots of bad points made in this paragraph, but the real point is the one made in the final sentence of this paragraph.
My lord,
Knowledge of the refusal to appoint the claimant is self-evidently different to knowledge about why that decision was taken. Then the punctuations are wrong. I mean, whether the decision maker and victimizer knew of her protected act and acted in such a way as to influence the decision. Again, it's not very well expressed, but it is the point we made earlier, isn't it?
And a bit further up, the judge's conclusion that belated disclosure pursuant to the DSAR in August 2020 did not change what the claimant already learned and properly described as perverse.
Yes. No, she doesn't say. She doesn't say why it was perverse.
No, she doesn't. But
that perversity point, my lady, is in relation to Mr. Barrett's involvement. So we say the judge was entitled to find that she knew enough, she knew what she knew, that it wasn't being progressed in 2018.
Maybe wrong to refer to Mr. Barrett, but the basic point that it's not clear that HSBC knew about her previous discrimination proceedings rather than simply being in a dispute. That again is the point we'd be putting to you, isn't it?
That, my lord, yes, but that doesn't appear from this particular paragraph in respect to the Mr. Barrett involvement point.
Yes, I see that. But
And it just shows confusion by the judge. And my lady, in answer to your question as to knowledge, we submit that the EAT judge simply put it too high. Further, knowledge of the refusal to appoint the claimant is self-evidently different to knowledge about why that decision was taken, whether the decision maker victimizer knew of her protected act and acted in such a way as to influence the decision not to appoint her. The EAT judge seems to be saying there that in order to pursue a claim in the Employment Tribunal, a claimant must know why, must have knowledge of why the decision was taken. That self-evidently can't be the case. It cannot be a requirement on a claimant in order to bring proceedings to know why.
no, but you can't bring a proceedings merely speculatively. You have got to have some basis for being able to say that the respondent, the intended respondent, was motivated by your protected characteristic. You can't just make it up. And if you then say, I suspect that it was because I was a woman, but I've really got no material at all, and then a year later, a whistleblower sends you a memo saying we don't want to employ Ms. Sengotta because she's a woman, that changes the picture, doesn't it?
Well, my lord, it adds to the puzzle. It adds flesh on the bones, but it's not a necessary requirement in order to bring a claim. Well,
But if you had no other material before that, other than the fact you were a woman and hadn't got the job, we'd all be saying you can't possibly bring a claim. It would be irresponsible. Well, in the old days, what you could have done is you could have served a questionnaire, but that procedure is not available anymore, is it?
my lord, no. In the case of Jones, which we have in the authorities bundle at tab 10,
So we look at Jones over lunch. What do you?
I'm really grateful, and in that case, the claimant went through a process of trying to investigate and seek answers and seek information before pursuing a claim, and that was taken into account by the tribunal in deciding that it wasn't just inequitable to extend time. And similarly to this case, that's what the claimant was doing here. The claimant suspected enough, we say, and the judge, by inference, was found, having heard all the material and having seen cross-examination, that she knew and she suspected she had information from Miss Asayag, and rather than presenting a tribunal claim in 2018, she kept sending DSARs. She kept sending text messages and WhatsApp messages, contacting. She, in August 2020, covertly recorded a conversation, etc. So we say that all of that material before the judge is similar to the case in Jones.
Well, why don't we read Jones over lunch? It's 1 o'clock. If we were to give you another quarter of an hour after lunch, will that give you enough time?
Yes, my lord.
Well, that's what we'll do.
I'm grateful.
That won't put you in any difficulty, Mr. Seagull.
I suppose it depends when you're going to rise.
Sorry?
I suppose it depends when the court's going to rise this afternoon.
Well, I think even if we rose promptly at 4:15, it wouldn't put you in any real difficulty.
I was proposing to address you for 2 hours, so that would be perfect.
Well, strictly speaking, it wouldn't, because
hoping you wouldn't
Senator
notice.
is entitled to a reply. But I think we'll give Miss Timber her 15 minutes. We'll work something out. I mean, if necessary, but this is not an encouragement. I think we can sit to 4:30.
I will try to finish by 4, but as I say, I was anticipating taking.
Well, there is truth in what I said, that you shouldn't have to take as long as Ms. Sengupta.
Of course.
And she has only, on this basis, been 2.5, but she will have been 2 3/4 hours. You will then be 2 hours. No, she has a quarter of an hour left. I don't think that's that enough.
No, it sounds very fair. 3 to 2.
Very well. 2 o'clock.
Thanks.
Just one moment.